Hello, students. In our previous lecture, we have traced the journey of the evolution of human rights and the various landmarks in the form of American Declaration, French Revolution, English Bill of Rights, etc., etc., and how they shaped the emerging human rights documents in the years to come. In the post Second World War era, the human rights got momentum, or rather, the world community was now thinking of making these rights, these achievements, document in the form of uh, universal rights to be documented through a body that has a global reach, that has a global acceptance, and therefore, through United Nations, the world community decided to uh, gift the entire regimen of human rights to the world community. The purpose was that these basic human rights values of right to life, liberty, property, rule of law, democratic government, constitutional government, limited government, uh, representative form of government should acquire global acceptance. And we should try to make the world free as much as from atrocities, undemocratic elements, and all the rights should be equally available to all. Therefore, through the agency of United Nations, the world community introduced the International Bill of Rights, which forms the very foundation of the modern human rights system. The term refers to three key instruments: the Universal Declaration of Human Rights, UDHR, of 1948, and two binding treaties adopted in 1966: the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Together, they express the global consensus that liberty, equality, and dignity belongs to every individual. These documents transformed moral ideals into international law and continue to guide national constitutions, including India. However, it would be wrong to say that these documents talk only about rights. They also make a reference to the duties of the people, duties of the state, duties of the world community to bring or to implement the basic human rights values on the grounds and enforce them equally to all. Today's lecture will cover five major themes. First, we will look at the historical background that led to the rise of global human rights law after World War II. Then we will study the UDHR 1948, which was the first international statement defining human dignity. After that, we will examine the International Covenant on Civil and Political Rights, ICCPR 1966, and the International Covenant on Economic, Social, and Cultural Rights 1966. The two treaties that make human rights legally enforceable, which provide we will also discuss the optional protocols of these covenants, which provide the mechanisms for individuals to seek justice under international law. Further, we will explore India's role and ratification process. Finally, we will end with a comparative analysis of all the three documents and their continuing relevance for modern democratic governance. By the end of this lecture, you should clearly understand how human rights evolved from moral ideals to enforceable global standards and how these treaties have shaped international and national legal system. Before I start with UDHR, I would like to draw your attention to the fact that the very first difference that the human rights movement made to the concept of rights was that it changed the language of rights. While throughout we have been talking about rights of men, rights of mankind, or all men are born equal and all men have equal rights, now we were talking about human beings. All human beings are entitled to this right or that right. And nonetheless, to mention that an Indian representative, Hansa Mehta, played a crucial role in changing this language of rights. It was she who literally insisted Mrs. Roosevelt to alter the language, either to use all men and women are entitled to all these rights, all men and women are born equal and therefore entitled to right to life, liberty, property, blah blah. Or else we should use the gender neutral term human beings. UDHR, Universal Declaration of Human Rights, was adopted on 10 December 1948 by United Nations General Assembly in Paris. The drafting process was led by Eleanor Roosevelt, who served as chairperson of the Human Rights Commission. The drafting committee included notable thinkers like Rene Cassin from France and Charles Malik from Lebanon and P.C. Chang from China, representing diverse legal and cultural traditions. UDHR consists of 30 articles outlining civil, political, economic, social, and cultural rights. It was adopted with 48 votes in favor, none against, and 8 abstentions, showing remarkable international consensus just 3 years after World War II. The declaration was not a legally binding treaty, as you can make out from the term. It's a declaration, but it has a moral and political commitment. Its purpose was to proclaim a common standard of achievement for all people and nations. The UDHR set the foundation for later treaties, including ICCPR and ICESCR, which would make these principles enforceable as they were covenants, and covenants are legally binding. Even today, the UDHR, despite not being legally binding, is the Bible of human rights, a global symbol of hope and equality, and the most important milestone in the history of human rights. And it is the base of all the forthcoming human rights treaties and conventions or declarations. So it laid the foundation, it laid the foundations, or it became the landmark that was going to guide the future generations in towards building a more strong, a more broad, a more comprehensive human rights regimen for the world. Now let us understand the core principles and global reach of the UDHR. Article 1 opens with a powerful statement: all human beings are born free and equal in dignity and rights. And mind it, earlier we were saying all men are born free and equal in dignity and rights. Now we are saying all human beings are born equal, free and equal in dignity and rights. This means that every person has inherent worth regardless of race, gender, or status. Article 2 ensures that no one is discriminated against based on color, language, religion, or political opinion. Article 3 establishes the right to life, liberty, and personal security, while Article 5 prohibits torture and cruel or degrading treatment. These rights are considered universal and indivisible. What makes the UDHR extraordinary is its global acceptance. It has been translated into more than 550 languages, making it the most translated document in the world. Though not legally binding, it has influenced over 100 constitutions and many national laws. Every year, 10th December is observed as Human Rights Day, marking its adoption. The UDHR continues to be the moral compass for the international community and the foundation for all later human rights treaties. Coming to economic, social, and cultural rights outlined in the UDHR, these rights are as important as civil and political ones because they ensure human dignity through welfare and opportunity. So, when we talk about generations as civil and political rights being the first generation rights, social and economic rights being the second generation right, the very fact that they all have been incorporated in UDHR is enough to justify the equal importance of all kinds of rights, whether they are first generation or second generation or belong to any other generation. Rather, next few generations are only the expansion of first and second generations. Article 23 gives every person the right to work, to choose employment freely, and to receive equal pay for equal work. Article 25 declares that right to an adequate standard of living, including food, clothing, housing, and medical care. Article 26 emphasizes the right to education aimed at the full development of the human personality. Article 27 provides the right to participate in cultural life and to benefit from scientific progress. These rights remind us that human freedoms must also include the right to live with dignity and security. The inclusion of these social and cultural rights later inspired the International Covenant on Economic, Social, and Cultural Rights, ensuring they would become legally binding on states. Also, they expanded the state's area of activity, state's jurisdiction. They put an extra liability on the states to remain and to expand its role as a welfare state. Unfortunately, we can see a sharp contradiction in this with globalization. With globalization and states adhering to the LPG principles, liberalization, privatization, and uh, globalization, one can see a sharp reduction in the welfare goals and welfare activities or the welfare role of the state, wherein state is now shying away from its responsibility to guarantee food security, livelihood security, right to work, ensuring an adequate standard of living, housing, and medical care, etc. So, definitely, despite the fact that UDHR is the basis of all the forthcoming human rights treaties, but the very fact that the states are morally not accepting it is something to be cogitated upon. While the UDHR was a revolutionary achievement, it was only a moral declaration and not a legal treaty. This meant that governments could support its principles but are not legally obligated to follow them. During the Cold War, ideological divisions deepened. Western democracies prioritized civil and political freedoms, while socialist nations emphasized social and economic rights. To resolve this divide, the United Nations decided to draft two separate but complementary covenants. The first was the International Covenant on Civil and Political Rights, and second was the International Covenant on Economic, Social, and Cultural Rights. Both were adopted on 16 December 1966 and came into force in 1976 after sufficient ratifications. Together, they gave legal effect to the principles of the UDHR and created obligations for states to respect, protect, and fulfill human rights. These two covenants turned the universal ideals of 1948 into enforceable international law. But one thing to be highlighted here is that while initial plan was to pass the two covenants along with UDHR in 1948, however, the ongoing Cold War rivalry pushed this idea of passing or accepting or adopting ICCPR and ICSCR immediately. And that shows the rhetoric in the slogans in the dialogue of the developed world that human rights were mere sophisticated garbs for these developed countries to expend or implement their own agenda of ideological warfare or hegemonizing the world by imposing their own ideals. That shows their non seriousness towards the entire movement of human rights. It was only in the decade of 60s, that was the time, mid 60s, because most of the Afro Asian countries were now getting independence from the colonial rule. And the process of decolonization was about to be completed. And therefore, maybe it was the fear from the newly emerging nations and their upcoming agendas that the superpowers or the countries of the West suddenly decided to fasten up the process of adopting these covenants, ICCPR and ICESCR. The International Covenant on Civil and Political Rights was adopted on 16 December 1966 and entered into force on 23 March 1976. It contains 53 articles organized into 6 parts. The covenant ensures fundamental rights such as life, liberty, fair trial, equality before law, and freedom of expression and religion. Its implementation is monitored by the United Nations Human Rights Committee, composed of 18 independent experts who review periodic reports submitted by by the member states. India signed and ratified the ICCPR on 10th April 1979, making a few reservations on Article 1, that is self determination, because obviously India itself was going through the process of nation building. And adherence to self determination might have created problems of unity and integrity in the country. And Article 9, that is arrest and detention. Obviously, we were a new democracy. We were a democracy in making. We were a nation in making. And therefore, some kind of strict action or some kind of control of dissent was felt necessary by the state. The covenant holds states accountable for respecting individual freedoms and for providing remedies against violations. It is considered one of the most comprehensive international treaties on personal and political freedom. Two optional protocols were later added to strengthen its enforcement. One allowed individuals to complain to the UN Committee, and the other aimed to abolish the death penalty worldwide. Definitely, both were very pragmatic steps. Now, let us examine the core civil rights protected under the ICCPR. These rights originate or they constitute the very heart of human liberty and justice. Article 6 declares that every human being has the inherent right to life, and this right shall be protected by law. It strictly limits the use of the death penalty and encourages its abolition. There was a time when, even for pickpocketing, capital punishment was given in England. Article 7 prohibits torture or any cruel, inhuman, or degrading punishment. This article directly influenced many national laws, including India's constitutional protection under Article 21. Article 8 bans slavery, servitude, and forced labor in any form. Article 9 guarantees the right to liberty and personal security, protecting individuals against arbitrary arrest or detention. Article 10 ensures human treatment of all persons deprived of liberty, such as prisoners. Article 14 establishes the right to a fair trial, equality before courts, and the presumption of innocence until proven guilty. And this became, you know, the foundation of Indian jurisprudence, that a person is innocent till his guilt is proved. However, there are a number of undemocratic laws also in our country that put it upside down. Like, for example, to address the issues of terrorism, insurgency, uh, the state is forced to reverse this, foundation of Indian jurisprudence, one of the fundamental principle of Indian jurisprudence. So, to deal with the heinous crimes like terrorism, insurgency, militancy, a person is declared guilty and he has to prove his innocence. Of course, there's the borderline between security of the state and freedom of people is very, very thin, and we have to maintain it very delicately. These civil rights form the foundation of due process, ensuring that no government can act arbitrarily against its citizens. The ICCPR thus transforms the moral values of the UDHR into enforceable legal duties, obligations, obligating governments to protect these fundamental freedoms at all times. In addition to civil liberties, the ICCPR also protects political and individual freedoms that allow people to express their beliefs and participate in governance. Article 17 safeguards the right to privacy and protection from arbitrary interference in family or correspondence. Article 18 guarantees freedom of thought, conscience, and religion, including the right to change one's religion or belief. That is, right to propagation also is included. Article 19 ensures freedom of opinion and expression, which includes right to seek, receive, and share information. Article 21 protects the right to peaceful assembly, while Article 22 recognizes freedom of association, including right to form and join trade unions. Article 25 establishes the right to take part in public affairs, to vote, and to be elected. Together, these rights form the backbone of democracy and political accountability. We have, under Article 19, the Right to Information Act that has proved as a big tool in furthering or strengthening democracy and transparency in the system. Uh, they make it clear that citizens must be free to criticize, organize, and participate without fear of repression. By guaranteeing these freedoms, the ICCPR ensures that governments derive legitimacy only through the consent of the government. These provisions have inspired movements for democracy and freedom around the world, from Europe and Asia to Africa and Latin America. The ICCPR also focuses on equality, family protection, and minority rights, which are vital for social harmony. Article 2 obliges states to respect and ensure all rights without discrimination of any kind, such as race, color, sex, or language. Article 3 guarantees equal rights for men and women in the enjoyment of all civil and political freedoms. Article 20 prohibits war propaganda and any advocacy of hatred or violence. In the light of this, government may even curb the freedom of speech and expression. Many times, in order to maintain rule of law, in order to give security to the people, in order to protect right to life and personal liberty of the people, government bans in India the access to internet, many times bans internet in certain areas to control propaganda, hatred, or violence. Article 23 recognizes the family as natural and fundamental group unit of society and affirms its protection by the state. Article 24 ensures that every child has the right to protection without discrimination and to a name and nationality. Perhaps this became the foundation of CRC, Convention on the Rights of the Child. Article 27 provides special safeguards for ethnic, religious, and linguistic minorities, allowing them to enjoy their own culture, religion, and language. And to a large extent, thus, we have addressed the tussle between universal human rights and cultural relativism. These provisions highlight that freedom and equality are not separate concepts but interconnected. Without equality, freedom becomes privilege. By including these articles, the ICCPR reaffirms the idea that human rights apply to everyone, not just the majority, not just the dominant sections, that the protection of vulnerable groups strengthens democracy itself. The enforcement of the ICCPR was further strengthened by two optional protocols, which extend its reach beyond state level accountability. The first optional protocol, adopted on 16 December 1966 and in force from 23rd March 1976, allows individuals to file complaints directly before the UN Human Rights Committee if they believe their rights under the covenant have been violated, after exhausting the national remedies. This mechanism gave people an international voice when domestic systems fail. I think the real strength of the human rights movement lies here, that when state system does not respond, people have other platforms also. Undoubtedly, state is still the best protector of human rights, but then it is also the worst violator of human rights. And if a state is violating the human rights, then it is difficult to challenge for an individual. And therefore, this particular provision is very, very important for people to protect their human rights. Second, optional protocol adopted on 15 December 1989 and in force from 11 July 1991 seeks the abolition of the death penalty. It obliges the states to ensure that no one within their jurisdiction is executed. These protocols apply only to countries that have ratified them. India has not signed either optional protocols, though it follows many principles in practice. Both protocols show that international law has evolved from mere declarations to mechanisms that allow victims of injustice to seek redress at the global level, strengthening accountability and promoting human dignity worldwide. Now, let us move to the International Covenant on Economic, Social, and Cultural Rights, which was adopted on 16 December 1966 and entered into force on 3rd January 1976. This covenant recognizes that true freedom requires not only liberty but also social and economic equality. It contains 31 articles organized into 5 parts. ICESCR ensures rights related to work, fair wages, social protection, education, health, and adequate living standards. These are called positive rights because they require government action to be fulfilled. The covenant obliges states to take progressive measures to the maximum of their available resources. Implementation is monitored by the UN Committee on Economic, Social and Cultural Rights, CESCR, which examines periodic reports submitted by countries. India ratified the ICESCR on 10th April 1979, committing itself to advancing welfare and equality through economic and social development. This is also the decade of 1970s, 78 onwards, that we see lots of judicial activism in India and judiciary time and again expanding the otherwise narrowly defined basic rights, like, for example, right to life, that was defined almost 3 decades before as simply physical freedom from death and detention only, was expanded since 1978 onwards to include Article 14, Article 19, and many more freedoms, including food security, right to safe drinking water, right to basic health facilities, right to good roads, right to pollution free environment, etc. etc. The decade of 70s is no doubt very, very important in context of human rights, as we can see many, many new inventions correlating civil and political rights with social and economic rights. Speedy trial, free legal aid, freedom from torture, security or protection from sexual harassment at workplace for women, they all became part of, justiciable fundamental rights. And in a very healthy manner, judiciary brought about a fusion of social, economic, civil, and political rights to make the human rights regimen appear very, very comprehensive in India. The covenant affirms that without social justice and opportunity, liberty alone cannot guarantee human dignity. Let us look at the key articles of the ICESCR, which covers a broad range of welfare rights. Article 6 recognizes the right to work and the opportunity to freely choose employment. Article 7 ensures fair wages, safe working conditions, and equal pay for equal work. Article 9 recognizes the rights to social security and social insurance, ensuring protection against unemployment and old age. Article 11 guaranteeing guarantees an adequate standard of living, including food, clothing, and housing. Article 12 grants the right to the highest attainable standard of physical and mental health, which includes public health and medical care. Article 13 establishes the right to education at all levels, ensuring that primary education is free and compulsory. These articles show that the covenant's purpose is to make freedom meaningful in people's daily lives. Rights to food, work, health, and education create a foundation for dignity, equality, and participation in society. And I would give the example of India. When 78 onwards, when judiciary declared right to life as a right to live with dignity, our judiciary made right to food, work, health, and education also the fundamental rights, justiciable, and are to be guaranteed by the state at any cost. Without these rights, democracy definitely is incomplete because it is because of ICESCR that political democracy granted by ICCPR becomes comprehensive as this covenant guarantees economic democracy. So, through this, we have brought about a healthy amalgamation of political democracy and economic democracy. ICESCR's enforcement was strengthened much later through the optional protocol adopted on 10 December 2008 and enforced from 5th May 2013. This protocol gives individuals and groups the right to submit complaints to the Committee on Economic, Social and Cultural Rights about violations of their rights. It also allows the committee to conduct inquiries into grave or systematic violations by states. The protocol recognizes that economic and social rights deserve the same international protection as civil and political rights. It promotes accountability and justice for victims of poverty, inequality, and discrimination. The optional protocol applies only to states that have ratified it. India has not yet signed or ratified this protocol, but many of its principles, as discussed just few minutes ago, are reflected in national schemes and constitutional directives and judicial interpretations. ICESCR and its optional protocol together ensure that governments are responsible not just for protecting freedoms but also for creating conditions in which all people can live with dignity, health, and opportunity. India has played a vital role in supporting international human rights law. It ratified both ICCPR and ICESCR on 10th April 1979, officially becoming a party to the International Bill of Human Rights. However, India entered reservations regarding Article 1 on self determination and Article 9 concerning arrest and detention. The reasons were obviously political and sensitive to the entire process of nation building. India has not signed the optional protocols of either covenants but continues to submit periodic reports to the UN committees. Importantly, many of these rights are already guaranteed under the Indian Constitution. The Fundamental Rights Part 3 reflect the ICCPR's civil and political freedom, while the Directive Principles of State Policy Part 4 mirror the ICESCR's social economic goals. Indian courts, such as Indian court cases, starting with Menaka Gandhi, Francis Koralai, MC Mehta litigations, Nilabati Behra, Vishakha versus State of Rajasthan, have used international human rights treaties to interpret constitutional rights. Thus, India has integrated global standards into its domestic framework, showing that constitutional democracy and international law work hand in hand to protect human dignity. Let us compare these three documents. The UDHR 1948 contains 30 articles and serves as a declaration of moral principles. It is not legally binding but sets universal standards. The ICCPR 1966 with 53 articles make civil and political rights enforceable in law. It protects freedom, participation, and justice. The ICESCR 1966 with 31 articles focuses on economic, social, and cultural equality, ensuring welfare, education, and healthcare. The optional protocols to these treaties allow individuals to file complaints and promote accountability. Together, they formed the International Bill of Rights from 1948 to 70, spread over a period of, say, 48 to 76. These instruments are interconnected and indivisible. Political liberty is meaningless without social security, and equality has no value without freedom. UDHR gives the vision, the ICCPR ensures liberty, and ICESCR guarantees dignity and development. The International Bill of Human Rights has had a profound and lasting impact on global governance. It inspired later treaties such as CEDAW 1979 on women's rights, the Convention on the Rights of the Child CRC 1989, and the Convention on the Rights of Persons with Disabilities 2006. It also influenced regional charters in Europe, Africa, and the Americas. Today, more than 170 countries are parties to both the ICCPR and ICESCR. These instruments serve as the backbone of international law and a moral guide to for national constitutions. They have shaped global institutions, civil society movements, and judicial systems. Courts across the world, including in India, refer to these treaties when interpreting laws. The International Bill of Human Rights has thus transformed the idea of justice from a national aspiration into a global commitment, ensuring that dignity, freedom, and equality are recognized as the birthright of every human being. In conclusion, the journey from 48 to 1966 represents the world's most important landmarks in the evolution of moral and legal thought pertaining to human rights. The UDHR gave us the language of universal human dignity. ICCPR and ICESCR turned that language into enforceable law, making governments legally accountable for protecting liberty, equality, and welfare. The optional protocols added individual complaint mechanisms, and encouraged the abolition of the death penalty. India's ratification of both covenants in 1979 linked its constitutional philosophy of justice, liberty, equality, and fraternity to the global human rights movement framework. Together, these instruments continue to guide lawmaking, governance, and civic responsibilities across the world. They remind us that peace and progress cannot exist without justice, and that human rights are not privileges given by the state but the birthright of every individual everywhere. Thank you.